So you got to flip that relationship. And you do it with a counterclaim. The counterclaim comes back and says, hey, wait a minute, I'm the sovereign here, and you guys are doing this wrong. And when you challenge jurisdiction, that's the point. When you're challenging jurisdiction, everything stops because they have to prove to your court that they do have jurisdiction.
Could that be rephrased to say that they're giving a presentment, and unless you counter that presentment, it stands?
Well, yeah, you can put it in commercial terms if you want. I mean, it's pretty much the world operates by the same formula regardless of how you label it. You know, it always starts off with somebody presenting something, accusation or request or whatever, and then the other person comes back and says yay or nay, and then the other one comes back another time. You know, that's the pattern of life.
Okay, and in this case they're giving a presentment, and when you counter it in court without doing a counterclaim, they just overrule you and go on.
Right, yeah, because see, you're not saying that they injured you, you're saying I haven't injured him. Well, so the question centers around the complainer. So you've got to come back, and you see, normally the defendant, by custom of what we say, okay, what we say isn't necessarily what we do, but by custom of what we say, the defendant is innocent until proven guilty. But that's not how it works, really.
No.
You're guilty until proven innocent.
You're condemned
Sure. And the proof of that is if you don't answer, you default and you are guilty. See, that's how it works. Now, that doesn't work that way in criminal proceedings. See, criminal proceedings, if you don't answer, they have to find you, catch you, and bring you in before they can default you. And it's not a default. They have to go through the paces.
Right.
So they, in the civil type thing, or in the common law situation, the accusation is made, and then there's the default or the presumption, and then the only way you can get around this is you have to say, wait a minute, where is your jurisdiction? In all proceeding, normally, if you make an accusation, you have to also provide the evidence. When you challenge jurisdiction, that is the one exception to the rule. When you challenge jurisdiction, all you have to say is, what jurisdiction? And the burden is on the defendant to prove that he had jurisdiction in his case. That's the one case where the burden of proof falls on the accuser. On the defendant. Actually, counter-defendant. Okay? So he cannot proceed until he proves jurisdiction. Now, if you don't question jurisdiction, he automatically has. There's another rule. If you fail to object, it means you agree. That's universal among all courts. You have to object. And you object with a counterclaim, or you object by other methods. But if you don't do any objection, that means you agree. So here we are, Sherry Jackson again. They made the accusation. She never objected to the law. What she said, I'm guessing, is, where is the law? Show me the law. And they did, only she didn't know it. And her attorney didn't know it. I'm sure he didn't know it. I'm sure. These guys are not that bright, okay? I mean, they're intelligent, yes, but they're not that well educated. I mean, this is a whole completely different view based on sovereignty and such. They don't get that kind of training in law school. So he looks at it, oh, all right, this is the accusation, so we do the standard defense. And then they get convicted and everybody wonders why. Look at Irwin Schiff, okay? Irwin Schiff, same deal. He got, I guess, indicted. In his case, I think he got indicted. But nevertheless, now I talked to Irwin Schiff, and I could just tell, just by the way he reacted, he wasn't really seeing it, what I was saying to him. Of course, I only had a few seconds really to talk to him because somebody else had convinced him to call me, okay? And so we eventually got together in a discussion, and we talked for, I guess, a half hour, something like that, a good length of time. It was about a year before he got convicted. I don't know when he got convicted. October 2006 was the conviction, so it must have been a couple years before that or something, or a year, I don't know. I'm not tracking it. But the point is that just before he went through all that, well, maybe a year before he actually got convicted, I tried to tell him this stuff, and I tried to bring it to his attention about 26 U.S.C. 7806, which says the rest is not law. He didn't buy any of it. And then he just before he hung up, he said, well, I'll call you later. I'll get back to you on this. And I said, I don't think you will. But I could just tell by the way he's receiving it. I was just simply on Mars, you know. Somebody coming in and saying that you can dump the judge and that type of thing. It's just, but you can see here, I've got the cases that back up what I'm saying. Presumably you're looking at exactly what I'm looking at, and presumably you can come to the same conclusions I do based on those same things. But it was just too far out for him, and he stayed with the standard route of defending. But the problem is that the government was absolutely out to get him. And so that judge did everything within his power to stop the appropriate evidence from getting to the jury. Okay? And they are, yeah.
Did you look at the Larkin Rose case at all?
No, but you see, Larkin Rose doesn't answer my email. You know, I've written to him. Eventually I did get to him, and we did have some communication, but we went nowhere with it. See, Larkin Rose is a guru, okay? I mean, and my experience has been that everybody who truly, really in-depth knows their subject, and Larkin Rose does know his subject. I don't take that away from him. They can't switch to a different philosophy. See, it's not that they don't know or do know or don't know. It's a question of a system of thought. And this thing totally inverts the whole structure. Now, if somebody will listen to me several hours like you have, I can lead you through the path that leads to the conclusion. And then once you see it, well, at least I think it becomes obvious, you know. But you have to get down that path. Talking to somebody on the phone for 1 hour doesn't do it, see? And that's all I usually get with these guys. So there's not too much hope of them seeing this without somebody really spending some quality time with them and giving them an opportunity to challenge. And then, one more thing, they have to actually listen to the answer. And these people who are well versed in their subject area often are not good at listening. You know? Yeah, now look, I hope you guys pin me to the wall on this if I ever quit listening, okay? Because, I mean, I've seen the tendency in myself, too. You know it so well, somebody comes off the wall with something different, obviously they're wrong. Bad attitude, but it just, human nature, you tend to gravitate toward that. But I ask them a key question. Sometimes I try to offset, and rarely does it work, but sometimes it does. I'll say, all right, you go to court and you lose a case. What do? Who made the decision? They say, well, the judge did. All right, so how do you handle that? Well, we appeal it. Okay. I say, that's not what I do. So they say, what do? I say, I issue an order vacating his decision. Can you do that? Well, right, they can't do that, they don't do that, and they don't believe that I did it. Okay? So, you know, it's really tough to get through to people who already have basically, see, they've paid their dues. And I can understand somebody who's paid his dues to not exactly cotton to somebody who's just new in their minds, in this business. But I've been doing this now I've been at this since around 1983. Okay, but I didn't really get understanding until about 1990. That's when I started, and I didn't do it by myself. I had a tremendous amount of help from a lot of people, you know, and discussions and points of view and so forth. So it was a long road to coming to where I came on this stuff. And then hopefully it's organized well enough so that you guys can now pick it up and at least do something with it. We've heard a lot about the fact that when somebody is taken into custody, that they become an asset of some kind, where people can somehow the bonding process and so forth. But our purpose here in the seminar is to show you what the law is and how to deal with it. Not right now, yeah. Good. Give me time. Yeah.
And neither is Linda Wall of Preferred Services, because she did his approach. She didn't. I don't know if she used a counterclaim or not. But again, she questioned jurisdiction.
Right.
Jurisdiction. They dismissed.
It's easier. It's easier to do that dismissal with a counterclaim than it is because you're putting their paychecks at risk.
And one thing too, Mr. Bill, doesn't mean if you have to go to a building in the courthouse to be in court. When you're riding your car and you're in the street and the cop pull you, you're right there in court with them.
Yeah, right from the get-go,
Right there
you're in
from
court.
the get-go. They're acting as a judge the whole night, the whole shebang.
Anytime you have any interaction with these people, never forget that you're always in court, right from the beginning. The moment that cop opens his mouth and says anything that's against your interest, you're in his court. Okay? And yeah, so you right from the get-go, it's what's your authority. You know, you may still get arrested, but it's what's your authority. You can be nice about it. You can be non-challenging in the sense you say, I don't understand what your authority is. You know, you can be nice, but don't ever let that point get away.
I had one that worked. A cop pulled me over, the cracked windshield and expired registration. First thing I asked him was, where was the emergency? Was there a life-threatening situation? He said, no. Why? I said, when you turn on your lights, they're only supposed to be legally used for life-threatening situations. You didn't violate the law, did you?
There you go. That's a cute one.
He said, well, tell you what, fix your windshield and do your registration. I said, go.
Very good. Yeah. Well, I think, I haven't dug into that issue myself, but my understanding is that they can only pull you over for probable cause, and probable cause means the committing of an arrestable offense.
And
Say,
not only
a real
that-
crime, not an infraction. Okay, what we're going to do then is we'll jump to the next step, which is the remedy. Well, in a word, it's a counterclaim, and you challenge the jurisdiction. What is your jurisdiction? Let me show you, I can show you a format on the counterclaim so you can see it. Now the thing is that different courts have different formats. If you're in California, or if you're in the ninth, well maybe not, I won't say the Ninth Circuit, but at least in California there's a very definite statewide format, which is controlled by the rules. But you'll find in other states they have other formats. So what I'm saying here, the format may be different, but the elements are the same. You still have to say who the plaintiff is, who the defendant is, but where you put those things where you type them on the page varies from one jurisdiction to a next. But let's see. Let's go back to I'm a strong believer in the concept that I am no more interested in a person's case than he is. Saves me a lot of work. Not familiar with the case, no, but I'm sure it runs along the same lines. I mean, every person I've talked to, I mean, I know about Al Thompson, I know about Sim Cannon. There's another guy, Jerry something or other, who was out toward Redondo Beach somewhere in that area, and Irwin Schiff, and all these guys, they defend. You can't defend in deals like this. I mean, it's a slam dunk pretty much to get you. Once in a while, one of them gets through the system, like, that attorney, what's his name?
Cryer.
Yeah, Cryer. Tommy Cryer was I won't say he got lucky. I'm sure he did his research and he was very effective, but it was a fight right down to the end. With this approach, the fight pretty quickly comes to an end because suddenly you're issuing orders. That's a lot nicer position to be in. Let's go to
Bill,
yeah.
Cryer had Beecroft, who is
Yeah.
a theory attorney. He's
Yeah. Well, I remember Beecraft. I have on my website. I have a challenge to Larry Beecraft. When I started talking about sovereignty, I was fine with Beecraft until I brought up sovereignty. Sovereignty is what gets you out of their jurisdiction. See? He about blew a cork. I mean, he was yelling at me. He was calling me names. And then finally he stormed out of there and took Bill Benson in tow with him. Let's see if I can find it. First of all, I want you to show you how to structure the lawsuit itself. Let me explain something about the term lawsuit. Now, I've been talking about lawsuit all along, but I want to tell you right now that legally speaking, I'm using the wrong word. What it really is that you have actions at law and you have suits in equity, or equity suits. When you talk about a suit, that's equity. When you talk about an action at law, that's law. Then along around the beginning of the prior century, they came up with this great, fantastic idea. They said, let's put them together. There's only one form of action. You ever seen that? So they have law and equity combined. They're no longer wanting to distinguish it. The problem is they have to distinguish it because the Constitution has not changed.